Obi. Yeah, me chow extra with you for now.
Omojo so official panso.
I can come back here no.
Yes. Me just say what jemre etimi etie voice a boy the venerable former electoral commission chairperson Kwadwo Afari-Gyan and in nsema waka ono call for sanctions on petitioner bia or the election petition be court one year successful no fit say was say ye twen waso mo saying because as a party mo candidate at the petition be sa court da mo saying
Okay, Obi, Uchi, the respected Afari-Gyan, or you see petition in this generic form. Now, obedience, there are several aspects of election petition.
Asempa FM.
Inti Omamuhano. Your presidential election petition, and your parliamentary election petition.
Yes.
As you are aware, a parliamentary election petitioner. Okay.
Yes.
Who we knew, who lose you, there is always costs associated with it. The presidential one, no, in your now make something on a lighter note. Into me, enemy senior, San Davis, and the Jomoro parliamentary election petition.
Yes.
So okay.
Mekaipa.
Inti sometimes I'm a senior brother Jeku. And it Mekai say November 21st or so 2022. And court may say over my judgment. Inti anopana ye court no. Early in the morning before judge in the bebano. And I'm the question so senior. The demonstration the African corner. Chekobase judge no rule in your favor with the show 9 ahead of time. The edu course the men the course they bring. They crowd the men the crowd. No, it's okay. I'll think about it. And we can fail to have it. And my judgment, kind judgment, you it was clear, say, on the petition has been dismissed. No?
Yes.
Nothing, no. You see, I go in my favor, no, now I need the costs. And I made say judge, in open court say good faith and management the costs. Because even before when my corporate chocolate if it goes against me, I'm not on the costs. So see I go in my favor. Good faith will not allow me to take costs. In a judge in Ankasan I say there will be no other as to costs. They bring it this other side just to demonstrate, say, as far as your parliamentary petitions are concerned, cost is always awarded. Cost always flows at the end of it.
Yes.
In Georgia, in Copa, men starting working underground, hoping say if it goes against me, of course no ever form. Until later, Grana make our open court. So this is the situation because already my career underground work, and that has come in my favor. And you had reached me at the cost. So it is something that we should always know. Say at the parliamentary level, no, parliamentary election petitioner, depending on the outcome, no, cost flows naturally. It's a matter of cost. Now, the problem relates to presidential election.
Mm-hmm.
Now, the respected Dr. Afari-Gyan draw parallel with the situation in Nigeria.
Yes.
Sebio, the Nigerian process is slightly different from ours. You can and say there are over 1,000 petitions. Reference to the over 1,000 petitions, it clearly should say he combines senatorial, gubernatorial, election petitions in the conversation.
Yes.
Because we are related to presidential petitions, no. Nigeria, they've had a lot of history relative to presidential petition. From 1999, almost set up a new constitutional arrangement. Almost every election in Nigeria in a presidential petition. Almost. From Yaradua Bresso, Abubakar, they cross with Tinubu, Peter Obi, and the rest. Now, if you just oppose that against the Kenyan scenario, I think we are done a bit better. In the sense to say, you started your presidential election under the 1992 Constitution. You're having about 8 presidential elections, correct?
Mm-hmm.
Of the 8, only 2 are ended up in the courts. Even though in 2004, Prince Owu, Mr. Portufe, and
I think Rojo Metal,
it was slightly different, and the level of publicity was not much.
Sure.
But also, in terms of publicity, the elevated election petition on the presidential election, the first was 2012 election, then the 2020. Into OSHA, the policy rationale of the 8 elections, so far only 2 have ended up in our courts. And I would be going to say, presidential election petitions are exclusively reserved for the Supreme Court.
Sure.
Unlike parliamentary, are flooding all the courts. That's what I say.
Yes.
And I strongly believe, sir, there's a certain public policy reason why one presidential election petition, as far as the 1992 Constitution is concerned, is exclusively reserved for apex courts. Like any original one, the defense of the Constitution is Article 2, and many such related original actions. There's a public policy reason why cost is not awarded, and simply traceable to the conversations that flowed after Tribal and Attorney General. Okaya, in the early 1980s, then a young lecturer at KNUST in the past, Dr. Nimako brought an action before the Court of Appeal then highest court of the land, about Wawuni Apalu appearing before the parliamentary vetting committee, having been so nominated as the Chief Justice of the new Supreme Court. Ukaya, the lawyers of the Attorney General then raised a preliminary legal objection as to the capacity of Nimako to even bring the action then. And that was when the Apex Court, I can't say, Nimako enjoyed a certain community of interest with the Constitution itself. And the rest is a matter of history. Now, fast forward to 1992, we inserted Article 2 specifically for a reason. Now, the whole idea, and then we say, citizens should have a say in protecting the Constitution itself. And that is why, when it comes to protection of the Constitution itself, the Supreme Court has exclusive original jurisdiction. Until recently, the Supreme Court used to guide that original jurisdiction, I must say, jealously. What I say?
Yes.
Now, OSHA electoral justice over the period, there's always the need to do a cost-benefit analysis. What is the cost implication of allowing a person who is dissatisfied with electoral outcome to resort to self-help or come to court? It does appear there's a greater public good or public policy consideration in opening the court for such a person and not consider the issue of costs when you look at it from the reverse. I recall vividly in 2012 when the declaration was made, and it was obvious that the then candidate Akufo-Addo, the running mate Dr. Mahmoud Bawumia, were not retained. He formed a group, Let My Vote Count, Okaya.
Yes.
And they were all over the place. Mekai, Taifa, and the rest, Mame Eslawusu, and the rest. They were all over the place. Eventually, 3 petitioners, in the person of Nanado Dankwa Akufo-Addo, Dr. Mahmoud Bawumia, and the late Jake, decided to go to the Supreme Court. At the end of the day, the Supreme Court acted properly in not awarding costs, regardless of whether it is 5-1, 4-5, or whatever. The Supreme Court looked at the circumstance and felt that it was a better approach coming to the court than getting your supporters on the street. In 2020, H. John Dramani Mahama approached the court. I do not, with respect to the distinguished Dr. Afari-Gyan, subscribe to the notion of awarding costs. I would rather urge that we tread with a lot of caution with some of these imported conversations, particularly using Nigeria as
an example. But lawyer, senior Gary is on the other line. Mekone hoba ansana no. Se utie Kwadwo Afari-Gyan doctor. I don't think, from what I listened to, in principle, he's against anybody going to court. What he seems to be against, and it's a man for a court based on ABR.
Yes. Let me just quickly respond to this bit, then you can go to my good brother,
yes,
Gary.
Yes.
Well, the question or the test of frivolity is not one that is open to any other individual but the court.
Sure.
What I say?
Yes.
It is one that is open to a court to come to a conclusion whether a suit is frivolous, vexatious, one that is an abuse of the court process, one that is without merit. What I say?
Yes.
So where you want a lawyer to ascribe unto himself the power to make a determination that this suit is frivolous and others, I disagree. I disagree. And thankfully, of the 2 election petitions that we've had in this country, the 2012 one, the 2021, the Supreme Court never came to the conclusion that the 2 petitions were frivolous. So I want to say that with a Ghanaian experience, we've not had the experience of the presidential candidate taking a frivolous matter to the Supreme Court. And that is why I'm saying that we need to exercise a lot of caution. And you see, the interesting part is that sometimes we take the peace that we enjoy for granted. We think it's a matter of course. No. The Supreme Court in the 2 election petitions, with the available skill sets, have been able to meander the vast issues in a very characteristic manner. And I just want it to be so. We should be cautious not to import very novel conversations into our electoral justice process.
Okay, I'll come back to you. Lawyer Gary Nimako, Director Legal, Edema NPP. Councillor Kwaba, Ekosi saying Sony.
Obi,
Nyamia Domame Pacho Onso. Adom Bibi Aboko. Entienne.
I said, my family and I'm more. Is she a meeting?
But the conversation Bibia the respected Dr. Afari-Gyan Ashas yes it was a drew mpempenswa say obi the petition eco court election petition court na say anko amana say court no hu say ade we out back court that's why be say yemre ne ade a was a court no etwi ni pakro aso say the be yemfa petitions are frivolous ne eni nyina so bia e be court lawyer Edudzi Tamakloe a draw the extension say for parliamentary election they call high court na say be call appeal be call court of appeal and they are nyina no there is an element of cost court no sometimes when mutimi award but for presidential no a Supreme Court yenya example bia of cost being awarded a be deterrence to bia onshade nyina so bia no person ko Supreme Court o je ne say me pa chaw council
yo obi I'm chair for you. Now, also, the issue of court and the issue of elections. Somebody winning an election and another one losing election. The losing party filed a petition in the court. It's a very complex enterprise. Very complex enterprise. Also, elections. There are a lot of emotions in it. For election, now Lusua. Obi, and ya agrodi. And ya agrodi cry. It's all down now. What that with them Munisa, what didn't you shall say elections, no? And ya ordinary thing. Now, I won't say what elections we are. Let's say, yes, Lusua. Support us, no? Almost thought that more free said that the election, it be a more short and one winning. Democracy and here. Now, there's a balance here. How to calm the supporters down? No more who say elections, no, and Papa more lose. And I say election, no, be a more winning and a certain areas be more disputed. Sometimes, no, you cannot use overnight to do all those things. And Obi, going to court, no, is another way, therefore, of calming down tensions to ensure peace and security in the country. Sometimes, because in the heat of the moment, you know, now I say election now, no, maybe I'm pampa one issue. Now, what we are maybe be answering for said, I be at the end, no. If you want, you lose her, you go ahead to her, I be highlighted every one of her. If I left for no more, I left for the bar, I'm a patient, so Makum said, be higher winning here, I lose here, I win it, I lose here. I can a couple more, any winning here. All these things are matters of vindicating your grievances. And I do not think, say, we should use monetary considerations as a yardstick to deter people from going to court. I don't think so. In any event, if you go to the process and you lose, mostly at the high court level, you see that the court are awarding costs.
Yes.
But these costs are not enforced. Go and check. Techimasa parliamentary petition. The court awarded costs. We never enforce the costs. But we went through the process, and at the end of the day, at least, you will say, but honorable in our one case now. I mean, there has to be cool heads here, balancing the peace, security, stability of the country vis-a-vis monetary gain. Because I am saying that most of them are not, you know. All these cases, no cost, no crowd, it is not enforced. It is not enforced against the losing party. And you're a bit careful and a bit cautious. They say, okay, fine. There are sometimes like case you want to be a depana who say a frivolous matter. I can give example of a petition, a course now I was Supreme Court. The case say pinch it in now, fill out case no Nanka also come when you are that's a different matter altogether. But then it calmed down the supporters somewhere. Go to the inn, and some lose no piano. There was no tension again. And sometimes, no, me feel say, not so much about money. There are a lot of balancing equations. What did you do to home before Boko Court? Calming your supporters down, it's part of it. Let your supporters feel say, yes, they are not the villains. They are almost more when sometimes you have to balance the equation. They not check out. And many say we should just say Sikasem, yeah, more than the cost. And I don't need the sole basis for why people should not go to court. Going to court is a matter of right. It's a matter of right.
Yeah, so, but on the argument, and it's say Obeko Quarter, you have to also take cognizance of the image and the credibility and integrity of the Electoral Commission. We are arbiters of our election in this country. Because the East Indians lose our credibility now. Peace now, yeah, pay or mine, Emma. And when you run to court without solid evidence, just to go drag the name of the EC in the mud, and to no other court than the apex court of the land, I don't think say a hot. And there was what they call assuage the pain of supporters. The Supreme Court.
You see, when we make the argument like that, that one everybody will understand it. If you are in the Supreme Court or you are in a High Court,
yes,
to denigrate a state institution, that is wrong. You see, let's distinguish the arguments. If you are in a courtroom, say how now denigrating the institution of Electoral Commission there, Obi, that is wrong. You don't go to court to assure your supporters pain by denigrating the state institution. That one it is entirely wrong. It's a no. But if you are in a courtroom to challenge a process, I will go through. I will finish it. What you went through, no, you ought to have won, but you did not win. And you are challenging the thing sheet by with evidence, credible evidence, and you lose. I don't see anything wrong with it. I don't see anything wrong with it. That is to say, you must gather your facts, gather your evidence, and make sure the law is on your side before you go to court. But the idea of delegating an institution of state to assure your supporters a pain, I know many will be an argument.
And do you then agree?
The argument stay at that level.
Yeah, do you then agree, counsel, say party na a petition no, and yes, our due diligence ni and gather solid evidence. Now, court, for the want of a better expression, they could waste court the time. The court should award cost against that party, even at the Supreme Court.
Obi, maybe cost, no. Many say that is the solution to the problem. I don't think so. You see, as I earlier once said, no, you can more the cost. You can more the cost, but I'm telling you, 99% that cost you are awarding in election petitions and all, it is not enforced. It is not enforced. I mean, no political party, after having won election petition, no, could you not say, I want the entry of cost. No, the entry of cost, could you not say, edit for crown, or could you can before? It is never enforced. It's never enforced. And it is never enforced. So the issue about cost, in itself, to me, is not the issue. What to me is the issue is the political party seeking to go to court, must make sure say, facts me very well. And we say the election, they ought to have been declared the winner, but they actually declare someone lose. But the PCT is showing say they won, and they go to court with credible evidence say they won. However, they say they have lost the case. So they lost the election petition, the election on the ground. That to me should be the argument. So if they go to court and then it's a business matter, and the court says, well, your case is a business matter, so we have dismissed your case and awarded cost. That cost that the court normally awards, that cost is not enforced.
Okay.
It's not enforced.
Okay, Maminko Edudzi, I'll come back to you and ask this question. And it seems that only Usinia Gary in principle seem to agree on a particular point. Maybe because I'm one of practitioners in our court, you see certain things every day, and that's why you've taken this position. But the point you earlier made, Edudzi said, the frivolity of a case is to be determined by the court and not a lawyer. But the court sometimes also expect lawyers, having perused the evidence to advise on more client. So the case of Mechanical Lloyd Assembly Plant in Nate, where the court took pains to explain the review jurisdiction of the Supreme Court. Now, the court said, and I quote, in part said, the review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. And court no cause so Emma the high standards you have to meet to invoke the review jurisdiction of the court. And the court sometimes expect lawyers to do these things right. And yes, me lose election into Charlie to assuage the pain of my way. Let me just go to the Supreme Court, not just any court, the Supreme Court, and go and waste the time of the court. And we think the court should not put in place measures to prevent people from wasting its time.
Okay, so any Gary, senior Gary Nimako. In 2016, the senior in a queen senator matter originating matter from the High Court. And I mean, the appeal Supreme Court. Every year, it was a 4-1 decision.
Yes.
For contemplating that maybe a review would be better. The review jurisdiction of the Supreme Court, as pointed out, for instance, in the Mechanical Law and Nazi decision, it's a tall order. But it's also true that there have been instances where people have succeeded on the review jurisdiction.
Yes.
So a lawyer, you cannot just sit at home and think, to my mind, this review will not succeed. Once the criteria or the threshold, you are convinced in your mind, sir, you are able to meet threshold. It will be possible for justices of the court to say, no, we do not see what you are saying, and therefore dismiss the action. But that should not be a bar from you exercising that right for or to a review. And the other thing I said, you see, election petitions are overconsumed generic. There's a reason why, in the wisdom of the makers of the 1993 Constitution, they didn't ask that you should go to a high court. Remember, this is about the presidency from which all other things flow.
Yeah.
It's not like parliamentary. It is in the wisdom of the framers of the 1993 Constitution, on say about parliamentary, I would call high courts. Now, over Zachariah and Nimako, you terminate at the Court of Appeal.
Sure.
What I say?
Sure.
Even now, the Supreme Court has, in a very interesting manner, assumed jurisdiction in some aspect of parliamentary challenge, flowing from the decision recently handed, that is
the
Afari-Gyan decision.
Afari-Gyan, yes.
Where it was a specific question of Article 94, but the Supreme Court assumed jurisdiction upon the filing of a suit and not a petition.
Sure.
What I say?
Sure.
And adjudicated upon it and handed over a judgment. So the point I'm making, is that as lawyers, even two lawyers that will sit in the same classroom, same lectures, they tend to see things differently. Me, dear, with the little experience I've had with election-related matters, I would always urge a certain level of caution. Okay. Let me give you an example. In 2008, the presidential you recall,
the
NPP led by my respected senior Akachia went before a high court to restrain the electoral commission. Okay.
Yeah, I remember.
Exactly. So lawyers, he didn't file a petition at the Supreme Court because at that time there has not been a declaration.
Yes.
You understand?
Yes.
So he decided to go to the High Court to get a restraining order against the declaration of the election. You may sit down and say about this lawyer, this is a frivolous. No. At that time, the client had come with a certain need that he thinks is legally permissible. Now there's a court that has said, look, this one is not permitted. That should end it. And like I pointed earlier, you see, presidential election petitions globally are not toyed with. Whether in the U.S., you remember our goal.
Yes.
It has to end up in the U.S. Supreme Court, right? The issues bordering Florida and many of those states.
Sure.
It ended up at the U.S. Supreme Court. That ends the conversation. So, you see, because of the challenges, the responsibility, the burdens associated with presidential election, I still want to maintain my position. So we should handle it with a lot of caution. A lot of caution. Thankfully,
yes.
Thankfully, two election petitions. And look, I will not say that the conversation is about the credibility of state institutions. It can always be picked out. Okay?
Asempa FM.
If you look at the Afro-Barometer report, 2019 by the CBE. Hello, Obi.
Me patron me Tiopa Council.
By the CBE.
Yes.
On how people rate, say, the electoral commission.
Mm-hmm.
Okay. Now, when the question was put, this was the Afro-barometer around 9 survey in Ghana 2022.
Yes.
Mm-hmm. Now, the CDP, as part of its work, for instance, put the question to the populace, quote, how much do you trust each of the following? Or you haven't heard enough to say. Now, the question was to the Electoral Commission. Can you imagine that only 9.8% of the populace said they trusted the Electoral Commission? An overwhelming, an overwhelming, almost 90-something% felt they never trusted the Commission. So sometimes it is even about how you conduct your activities, your affairs. That really speaks to whether people will trust you or not.
But it's also about how, through the actions and inactions of political parties, much chip away at the credibility of the Electoral Commission. And sometimes through what Afari-Gyan calls some of these frivolous petitions court to drag the EC's name in the mud.
Obi, let me tell you something. Mekai, after the 2012 election petition and the decision was given, right?
Mm-hmm.
I should think that Dankwa Institute or one of them organized a public forum, a public program. They show the speakers were the respected lawyer Sam Okujo,
yes,
Professor Michael Quay, among others. These are not children, quote unquote.
Yes.
They came out with their own analysis of the Supreme Court decision. And the public conversation that flowed after that 2012 election petition is a matter of public record. So, as to how the public will receive the product that may come from the court, either to the court itself or to the Electoral Commission, is something that we need to manage. And I say this because, you see, Obi, and the discussion had to do with the executive arm of government, correct?
Mm-hmm.
And we had to discuss something that Parliament can say,
yes.
I strongly believe the outcome or decision from the court. The court itself should have an internal mechanism, right, to absorb some of these rather rancorous, either condemnation or praise. What is important is the recognition that the court is the bulwark as far as the rule of law is
concerned. Okay, because of time. Yes.
We have a responsibility to work towards strengthening that bulwark
of our democracy. Yeah. Council, because of time, I would ask this final question, but I'll start with Gary. Sir, now, where do we go from here? Because another senior lawyer, he told me, sir, Osha Supreme Court are active cases, currently active cases before the Supreme Court. Over 300 active cases. If the apex court of the land had this load of work to do, how do we going forward say listen, yes, we agree presidential election petitioner sui generis, very important, anyway, but we have to put in place a mechanism to make sure we stop frivolous petitions from coming before us, the apex court, because Juma wa so dada. Lawyer Gary Nimako, what should the court do in responding to suggestion Afari-Gyan at the Amawono? Because we have to deal with the problem if we think it is a problem.
Obi.
Yes.
Can you quantify the cost of security and peace of a country to being in court, in a courtroom to vindicate your grievances peacefully?
Semper FM.
Quantifying the peace and security of a country. Let's even say the petition is frivolous. Let's even say, for the purpose of argument, it's frivolous, it's vexatious, it's whatever.
Yes.
The person took the route of going to a courtroom to make his case. At the end of the day, 3 months, 4 months, the judges say your case is frivolous. We have to dismiss your matter. So go. The country is peaceful. Just oppose that with a situation where the person says, I'm not going to court. I'm going to take the law into my hands and destabilize the country. Because if I go to court and they say that the case is frivolous, I'll be mortal with heavy costs. So I'm not going to court. Which one is a better route or better option for the country? I do not think that money should be used as a yardstick and my obedience could record. I do not think so. What I think should happen is for a lawyer before I go to court, yes, Obama say the facts. Obama done the evidence. Obama did the theory of his case. Now the law, not the law, the buana, and I say buana, no go to court. But you see, Obi, handling political related cases is not as the same as handling a pure land matter or pure commercial matter. Yeah. No, these are matters of law and politics intertwined. You see, that is where people are not getting it. Matter of law and politics together as one. It's not an ordinary commercial enterprise or an ordinary land case or an ordinary matrimonial case. No. A lawyer must be politically savvy to weigh a balance between the external and the internal, the political atmosphere of the country, the people's reaction, their emotions, the atmosphere, how they are feeling, and then take a pause, evaluate the evidence, and say, look, what do we do in the midst of this? What do we do? Yes, there are times that you go to court to calm down the tension in the atmosphere, which I know that my brothers on the other side have done it, I think, about twice or so. You calm down the tension, and after, at the end of the day, when the court rules that they have lost, the system is quiet. Mm-hmm. So for me, we have to be very, very careful and not to use monetary interest or punitive measures as anybody who brings case to court and the thing is frivolous, more the person with heavy cost. And so therefore, it should be a deterrent for people to go to court. For me, I don't think that is the way to go. Every lawyer will have to assess his law, assess the facts of the matter, and then make sure that as you are going to court, at least, by and large, you can say something to the judges. But that also, you should also know that let's look at the security of the state. And to me, that's an important thing. Look at how 2020 people were burning ties and all sort of things that they have won elections. Yet they do call and say, where's your evidence? They say, my farmer. That's what I say. My farmer. But the court, be able to say one farmer court. It could be a say, Ababoko. And for me, Obi, respectfully, I think we shouldn't use money as a yardstick for entering justice or assessing justice. I don't think that's what we should do. Access to justice is a constitutional matter. It's a matter of rights. And nobody can prevent them from going to court to have access to justice. If so, send someone there, crowd of court, court, someone there, you brought you out and take off. But every time it's about elections, elections, there are emotions involved. If you lose elections, Obi, and not from sir, and we call you para waboka. Why elections? Why campaign? Why nanti? Why the whole country? Why be it's a better amount. When you saw the winner, then the first will lose. Hey, Obi, enough from Sao. Enough from Saji. If you're a lawyer and they come to you with certain facts, say, lawyer, case you file my now so file a case the crowd.
Yeah.
Because the people will not agree. Say, what's the lawyer don't go court? What's on court? What's the lawyer don't go court? Obi, enough from sir. There is always a mixture of law and politics, at that level. And yes, and as simple as the way people see it, just say make your court, because there have been times that you have to fight some cases to equalize the number of cases the other far. There are times to balance the equation in the terrain. Obi, your opponents are far about 7 cases, parliamentary. You must also far equal 7 or even 8 to balance the equation. Okay? So they say, so if you win this one, you also win this one. If you lose this one, you also lose this one. Now equal to equal. So that's it. Mr. Mo, I don't think Sika should be the yardstick for having access to justice in our country. We should look at the security of the state. Obi, if the Supreme Court have about 300 cases, that's a man destabilize here. Can they sit and do the cases? They cannot.
Yeah.
If because of one political petition, election petition, no man destabilize here. They can't sit and do their work peacefully. It is nobody should underestimate political related cases like election petition, presidential election petition. Because for instance, NPP and NDC, we are very close with the numbers. Especially look at the way Parliament now is structured now.
Yeah.
It should tell you something. It's here for cool heads. Case by, you should take cool heads to deal with this matter. For me, I don't think it's about the money. We should look at a lawyer going to. But you see, one thing that you asked my brother Tamakloe. Let us build institutions very well. The nature of politicians. Then you have a electoral commission. You have now we declare my education lose one both. Then the next time, no, they are our enemies, and everything they do is wrong. But when you're on the other side, everything they do is right. I think we should let the EC, do their work, and let them try to do a very good job. Instead of when they declare for you, you'll be happy. When they declare for the other side, and you think, sir, to be honest with you, you can do a self-introspection. And we say, I did the election, you lose, but one chance and that's all go to there. Maybe you calm your supporters down, do 2-3 months, I will be attorney. And then after IPAC and then internal what do you call it, reorganization. And then we see how it goes.
Very well.
But for me, let us not use money. And if you see money and the country destabilize, then what happens?
Yeah. Lawyer, Medase Papa, Edudzi, finally, what should the apex court of the land, which is Lawyer Gary Nimako, Edudzi, the apex court of the land, and they are already inundated with cases.
Obi, like I pointed out, from 1992 until 2012, we've not had a presidential election petition for peaceful call.
Yes.
Now, when it happened, if you recall, that particular election petition lasted up to August that year. So that's about 8 months. Correct.
That's true.
Now, with the experience from the 2012 election petition, the Supreme Court rules have not been amended since 1996.
Mm-hmm.
But the Supreme Court said, CI 138 or so, that had to do with the issue of witness statements, among other things.
Yes.
Because the Supreme Court is exercising its original jurisdiction, and because the rules in the Supreme Court rules do not make room for the use of witness statement, because it's an original matter, the Supreme Court apply its own rule that allows it to adopt the issue of witness statement as pertains in the High Court.
Yes.
And by the adoption of that rule or that novelty, the 2020 election petition happened a bit more expeditious than it happened in the 2012. So I want to say that the Supreme Court itself has the necessary skill set to ensure speedy adjudication if the concern is about time. The whole idea that even petitions in Ghana are televised helps. So I just want to say that we should exercise a lot of caution in this conversation. The Nigerian scenario is slightly different from ours. And I would say Afari-Gyan on the same platform, Krana, said another analogy of the regional commission center. It makes the point say in Nigeria, because of the federal nature, unlike Ghana being a unitary state, electoral presidential elections, Ghana is considered as one constituency.
Yes.
In Nigeria, it is different. Beyond winning popular votes, you must also get a certain percentage from each state.
Yes.
To become president of Nigeria. And so they may want to introduce a regional or state-based coalition. You can make that determination of percentage at that state level to help make a determination who won the election. In Ghana, it is different. Constituency called Ghana. And that is why if you look at CI 27, Regulation 2.3, it says the Electoral Commission chairperson shall be the returning
officer sure.
For the presidential election.
Sure.
One person. So we need to be very cautious whilst we move on. And that, since I'm wrapping up, again, my party, the NDC, has made it abundantly clear that, for instance, the use of indelible ink should be maintained. The closure of polls at 5 p.m. should maintain. And in the particular instance of the 2024 election, 7 December happens to be Saturday. Our people in the rural areas typically will say that I want to go to my farm briefly before I come and cast my vote. So the dynamics changes once you begin to move into the hinterlands. And the use of indelible ink, OB, as you are aware, Article 42 recognizes only 3 qualifications to vote: citizenship, 18 years and above, and soundness of mind. However, in 2012, we decided to compile a biometric register and now provided Regulation 32 of CI 127 the opportunity for biometric verification. That is not in Article 42.
Yes.
Right? Now, persons who by reason of fiscal disposition cannot go through the biometrics, should they be denied the right to vote? No. So there is a layer called manual verification. How do you ensure that a person who has been manually verified will not go and come back again? The old wisdom of using indelible ink becomes even more pronounced. And that is why you notice that Jameson herself, when she was making CI 127, provided in Regulation 33(2)(c) that there should be a permanent mark on the voter having so cast your vote. I think these things are provided a certain checks and balance. And like I said, when it's not broken, do not fix it.
Council, medase papa bibi ani ebese di nkomo bio. Why? And lawyer Edudzi Tamakloe, Director Legal, NDC, and a lawyer Gary Nimako.